So today we're going to be talking about athletics and the role of the student athlete in terms of legal issues. So for this lesson, we're going to talk about an athlete's due process and whether or not they're entitled to it. We're also going to talk about their freedom of speech. We're going to apply some principles of freedom of speech in the discussion posting. And then we're going to review athletic scholarships, sex discrimination, Title IX, and athletes with disabilities, as well as discuss drug testing. And then at the conclusion of this video, I'm also going to talk about your final paper. So, in regards to athletes' due process, the question becomes whether or not an athlete has a property or liberty interest in playing sports. Now, this is an interesting topic because some courts said they do, some courts said they don't. So because of that, because of the uncertainty on whether or not there's a property interest, it's always good practice to give athletes some form of due process. Now, another interesting piece about athletes and due process comes down to the scholarship or the contract that they have with the institution. Now, they may have a legitimate claim of entitlement based on their scholarship or contract that they have signed. Now, in this instance, universities' practice doesn't establish the norm. There's so many policies and procedures and NCAA regulations and loopholes and other types of things that each case truly needs to be handled on an individual basis. Now, with the scholarship and athletes' due process, there's no expectation of renewal. So at the end of the year, if an athlete's scholarship is up and they don't receive a renewal of their scholarship, they don't need due process for that because there's not an expectation of renewal. Now, I presume some of this is going to be changing, particularly with the contractual relationship between an institution with the Northwestern football team and the court decision saying that they can unionize. So that's going to be very interesting to see the legal implications of that precedent. Now, in terms of athletes' free speech, players, like students, have First Amendment rights. However, their speech cannot disrupt the academic or the athletic program. Athletic institutions have an interest in maintaining order and discipline within their programs. Any internal issues that are not a matter of general public concern are not protected under the First Amendment. So discussing coaching disputes, locker room disputes, talking about players that can disrupt the team to the press can result in loss of scholarship or discipline. Those aren't protected under the First Amendment because they can cause a disruption. Now, like other students, athletes have the right to receive information. So, in essence, an athlete cannot be forbidden to interact or to speak with other students or be intentionally disconnected from other students, as they also have that right to receive information. But if there is a compelling state interest in terms of safety, then that could be argued that we are protecting our students. So restricting their communication to the press or restricting their communication to certain people may serve as a way to protect the student and the student's rights. Now, one thing I want to talk about is a captive audience. We haven't really discussed that, and we're going to discuss it in the freedom of speech a little bit more, but a captive audience is a group of people that cannot leave a setting to protect or guard their own privacy by avoiding hate speech. So with that being said, if you have a captive audience, there are things that cannot be done, and prior restraint can be exercised. So that's because they can't leave, and they need to be protected. So if somebody's being forced there, and they're being forced to hear hate speech or sexual harassment or other things of that nature, then there's no right to receive information. There's no freedom of speech. So how does that fit in with athletes? Well, some might argue that a sporting event could be a captive audience. However, it's not, because you can leave at any time. But the question still becomes, if an athlete is using vulgar language in a sporting event, do they have the right to do that because there are people there watching that event? And that's kind of what the basis of the case study question I've posed to you in the discussion is about, and the reading as well as this presentation will help you read that or answer that. So I mentioned athletic scholarships, and I think we're currently shifting with what a scholarship actually means. Right now, technically, it's uncertain right now what it means because the Northwestern case ruled that a scholarship and playing sports constitutes you being an employee because you're spending 50, 60 plus hours working towards something. But before that court case, it was generally ruled that a athletic scholarship did not make you an employee because it was a contract where you're promising to pay to play. And there's lots of different conference regulations on contracts, and the next contract becomes a matter of the letter of intent. Is the letter of intent considered a contract in terms of athletic scholarships? Some people argue it is, some people argue it isn't, but right now, legally, it is not a binding contract. It's more of a mutual understanding. Now, there are many ways to lose a scholarship, and there's a lot of times in the contract there will be a behavioral clause, failing to misrepresent somebody, plagiarizing, or some sort of academics, or even refusing to play. All of these things can constitute a loss of scholarship. That may beg the question, then, does the loss of scholarship constitute due process? Well, it depends on how the scholarship is set up. If the contract is in there and it's an explicit termination, then yes, because that is something somebody desired. No, due process is not required. Now, in terms of sex discrimination, this is where we get into Title IX. And the purpose of Title IX is that it is to help make sure there's equal funding, treatment to males and females in terms of sports. Now, Title IX only applies to institutions receiving federal funds because that's to guarantee that federal funds are not being used to perpetuate gender bias. And Title IX has a broader reach than the Equal Protection Clause because it affects private institutions that are also accepting federal funds, where the Equal Protection Clause generally just applies to public institutions. Now, in terms of the calculations of funds, athletic departments need to abide by a funding formula that looks at students' populations based on gender. So if you have an institution that's 75% female and 25% male, 75% of the funds need to go towards female sports. The same is true if it were predominantly male. I'm going to show that actual formula here in a little bit. But I want to talk about the measure of equality. So how does Title IX measure equality? Well, the first thing is mutual accommodations. Whether or not the selection of sports and level of competition effectively accommodates the interests and disabilities of members of both sexes. So that's very important. The next is to make sure that the provision the provision of equipment and supplies is equal. And again, this is all based on that funding formula. So if it's 75% female and 25% male, then the equipment and supplies need to reflect that. The same is true for scheduling of games and practice time. Females can't get 2 hours to practice, and males can get 15 hours to practice. It needs to be equal. Same thing with travel and per diem. They need to get the same rates and the same quality of travel. They need to have the same coaching and tutoring expectations and quality. The compensations of coaches need to reflect the industry standards as well as the funding formula. The sports facilities need to be comparable. Medical and training facilities need to be comparable. Housing and dining facilities need to be comparable. And the amount of publicity that one receives for a specific sport also needs to be comparable. So all of these things are used to determine whether or not Title IX is being applied, whether or not that men's and women's sports are being equally treated. So the first measure of equality was mutual accommodations, and this is where the sports and level of competition effectively accommodates the interests and disabilities of both genders. Now, this is important because that's the one that's generally challenged the most. So how do we determine whether or not that is met? Well, there are 3 measures. The first one is athletic opportunities equals the enrollment numbers. And so I gave the example, if there's 48% female I should say greater than, then there needs to be greater than or equal to 48% of female athletic opportunity. So females need to have an equivalent amount of opportunities to participate in sports, and the same is true for males. Now, if that's not true, the second measure needs to be a demonstration that the athletic program is expanding to a group that has traditionally been excluded. Think of Geyer v. Tennessee. It's the same principle there, just with athletics. Now, if this isn't met, then the third measure is that an institution needs to demonstrate that the interests and abilities of its members have been fully and effectively accommodated by the existing program. But in order to do this, it usually means that the institution needs to increase funding or needs to demonstrate that a group of underrepresented students are participating in the sport. So typically the easiest way to ensure that this is being met is either the first or the second measure. Now, in regards to disabilities, disabled students must be afforded an equal opportunity to participate in physical education, athletics, and recreational programs. Now, in order to qualify for this protection, they need to qualify under Section 504, which we've talked about. So a student needs to be disabled, which is defined as a physical impairment that substantially limits their major life activity. So, for example, a student with a concussion that's no longer permitted to play football, that wouldn't be covered under Section 504 because the physical impairment is not a major, does not impair a major life activity, whether that be walking, eyesight, touch, taste, whatever it may be. Now, in terms of the student's ability to play a sport, they must have the full capacity to play. So what that means is that a student must have the full capacity to play the sport. So in other words, their disability should not hinder their ability to play. So for example, a student in a wheelchair may not be entitled to play soccer, but would be entitled to compete in archery. A deaf student could compete in wrestling because being deaf does not impact your ability to wrestle. However, an institution can exercise a conservative judgment in terms of excessive concussions, possibility of paralysis, and other things of that nature. So if a student has some sort of disability that may cause injury to themselves, then that's where an institution can be conservative in favor of the student's safety. Now there's always that question of, does a disability impact the student, and who should decide that? Should it be the institution? Should it be liability? Should it be the student? And a good example of that is the deaf Seahawks football player who is legally deaf but has been able to play football to the national professional level. So that then begs the question, should deaf players be allowed to play football? Well, if they are able to play and they have a full capacity to play the sport, then there is no reason why they shouldn't be able to play. Now, the next topic is drug testing, and this is a highly contentious topic among athletes, particularly student athletes. And there's been a lot of challenges to drug testing, whether it's the 14th Amendment, the 4th Amendment, privacy laws, tort laws, institutional policies and procedures, civil rights statutes, and public institutions can receive challenges in all of these areas. However, a private institution generally only receives challenges in the last three, being tort law, institutional policies and procedures, and civil rights statutes. So it's very important when drug testing wants to be implemented that legal counsel and civil rights and all of those things are taken into consideration. So in regards to drug testing, it becomes a major issue under the 4th Amendment, not the 14th Amendment, because the 4th Amendment protects under search and seizure. And the question becomes whether or not the collection of fluids is a search and seizure issue. And it becomes a matter of the collection of fluids, particularly blood and urine, and I have a personal interest in my own blood and urine. So to have those taken from me then is a violation of the 4th Amendment. But then the issue becomes, how do we balance the interests of a government agency such as an institution, and personal liberties to ensure that there is fair play among all? So that's where we are able to do drug testing, and there are two general types. The first is targeted drug testing, and this is when there's a reasonable suspicion that an athlete may have used drugs. And I use the word reasonable. It can't be an assumed suspicion. There needs to be some sort of evidence or reason to believe that an athlete has been using substances. Now, if there is a random group of students that are tested without reasonable suspicion, there could be a challenge to that, but that is also generally considered appropriate to maintain fair play. However, whatever the policy is, it needs to be narrowly tailored and to be the least burdensome possible. So we've talked about that in terms of it being a compelling state interest. So as long as it's not a blanketed policy that forces students to give up their Fourth Amendment rights, then it generally is permitted. Now again, there's always the question of sports organizations, and then when you get into the professional and the Olympic Committee and whatnot, that's more of a private organization to where they are able to require drug testing, and if you refuse the drug testing, then they can say, okay, fine, you don't play with us. Now, because we have a government institution, drug testing is a lot more contested in terms of how it is done, and then the NCAA has a large role to play within that as well, because it is a private institution. But that's where state action doctrine comes into play. So the role of NCAA and the role of the government, the role of the institution, is going to determine the level of protection athletes have in terms of drug testing. So that concludes athletes and this lecture. Again, this is to supplement the reading. It's not to replace it. But now I want to talk about the legal issues paper. So first of all, you need to have 10 minimum academic primary sources. So these are books, legal reviews, academic journals, dissertations, technical or research reports, agencies such as the Substance Abuse Research Center or whatever it may be. If you ever have a question about the legitimacy of a journal, look at the policies on how it is published. So if you typically need to send in money with a manuscript, it's questionable. As long as it's peer reviewed, so as long as there are a group of people that are reviewing an article to determine the legitimacy and the academic nature of the article, then it's acceptable. So first-year newsletters or organizational newsletters, those are not permitted. Now, for this paper, there are going to be two sections. The first one is the literature review, and I'm asking that these be about 12 pages long. 10 to 12 pages long. I know the syllabus says 12 to 15, but we're going to scale it back a little bit. So the literature review is to be no more than 6 pages and no less than 5 pages. There is a penalty for that if you go over or under on that. The legal implications, it's the same thing. No less than 5, no more than 6. And when you're talking about the legal implications, I want you to think broadly as well. What different areas of higher education are impacted? What are the future implications here? What does this mean for higher education? And I really want you to think about this as how it relates to your literature review. In no way, shape, or form is this to be a review of legal cases. I want to be very clear on that. The literature review or the legal implications, neither of which should be a review of legal cases. That is not what I want. I want a literature review of a current issue. Now, if that involves a case, that is fine, but I don't want reviews of cases. In terms of the legal implications, I don't want you to review cases and tell me what the implications of each of those cases are. I want a broad overview and a broad thinking of a legal issue in higher education. So, in terms of the grading, I want you to look at the rubric that I submitted to you. 10 points for grammar and APA, 10 points for the literature review, background information, and 10 points for the legal implications. Within the lit review and legal implications points are a 2-point penalty, or 2 free points, it's whichever way you want to look at it, for meeting the page requirements. So if you don't meet the page requirements, you could lose overall 4 points of a grade for that. So please pay attention to that. Now, some things to think about in terms of, and most importantly, you need to turn this into TK20 and Courseden. Failure to turn it into TK20 will result in an F in this course. That is a requirement to submit to pass this course, is submitting your paper to TK20. Now, some things to remember for APA. Your quotations, no more than 2 quotations. You will lose points for this, and they need to be less than 40 words each. Paraphrase, do not copy. Do not copy. Paraphrase, and you need to provide citations for these statements. So your literature review is going to have a lot of citations because you're going to be paraphrasing a lot. You want to cite all ideas, concepts, theories, and research. Common knowledge is an undisputed fact. Okay, so I would bet that a lot of us don't have common knowledge in law. An example of common knowledge is that the sun rises in the east and sets in the west. Okay, that's an undisputable fact. I want you to ask this question: how do I know this? And if the answer is, well, I read it somewhere, or I remember it from this, or it came from that, then that tells you that you need to cite it. So always ask yourself, how do you know it? I want you to review section 6 for crediting sources in the APA manual. Page 174 is in-text citations, and then section 7 is the references, and page 217 is the legal citations on how to properly do that. APA, it should be easy points at this point for most of you. You've done it for the past 2 years now. If I suspect any plagiarism, each case will be dealt on a case-by-case basis, but I hope that won't be a problem. As always, if you have any questions, don't hesitate to contact me, and I'm always here to help. Have a great week.